Can I please ask to take your seats? So, okay, so we have some new persons today, great. So let's start the second day of the 5th Maritime Security course for the Atlantic Center. This morning we have the first panel, which is Climate Change and Challenges for International Law. We have the privilege to have today as moderator Commander Bernardo Brito Abreu, my dear friend, please. Thank you very much for being here. As speakers, we have Doutora Patrícia Galvão Teles, which is online. Good morning, Patrícia. And then we have Professor Aldino Campos and Rear Admiral Moreno, which will be joining us on the panel. Thank you very much for being here. I hope we have a fruitful session. Can we see Doutora Patrícia? Ah, okay, great, perfect. Patrícia, só um momento que temos que pôr aqui os headsets dos speakers.
Sim, senhora, eu da minha parte ouço-os perfeitamente.
Muito obrigado.
Se tiverem um de mão também dá, a gente vai passar.
Eles têm os headsets, mais fácil, força.
Muito bem, vamos lá. Se é muito mais de lado, não é? Não, acho que aqui. Quando eu me sentar não vou rachar isso. Está, Well, good morning, everyone. Thank you so much for the Atlantic Center for the invitation, and congratulations for such an amazing event. And also, thank you for the panel. Very briefly, my name is Luís Bernardo. I'm also a Navy officer, and at the moment I'm an advisor for the President of the Regional Government of the Azores for Maritime Affairs and Fisheries. I also coordinate multilateral program with international partners called the Blue Azores, which is responsible for actually creating the largest marine protected area network in the North Atlantic, which has just been approved late last year, also with its upcoming challenges within international law, as you can imagine. But with no further ado, I'll present our fellow panel members, and I will start with Dr. Patrícia Galvão. Good morning. Dr. Patrícia is graduated in law and holds a master and a PhD in international law. She's a member of the United Nations International Law Commission, where she is one of the co-chairs of the study group of sea level rise and international law. She's also director of Legal Affairs Department at the Ministry of Foreign Affairs and an associate professor at the Autonomous University of Lisbon. Dr. Patrícia, good morning. Well, the floor is yours. We'll have an initial presentation from the speakers, around 15 minutes the most, I ask you. And so within the scope of the International Law Commission, if you could please tell us a bit more about this this panel. With basically, I think we should explore this morning how the accelerating impacts of climate change are testing the limits of our existing international legal framework. Thank you, Dr. Patrícia. The floor is yours.
Thank you so much, and good morning to all. I hope you can hear me well. I can hear you and see you perfectly. I have to start by saying that it's really a pity that I'm not able to be present in Ponta Delgada with you. I tried my best and even asked the organization to wait a bit last minute, but I actually just came back from 5 weeks in Geneva at the International Law Commission this weekend, and so it was a bit difficult to immediately leave again. But I'm so happy to be in a panel with such distinguished colleagues and also friends. And I'm really happy to be able to share with you some thoughts on the challenges that climate change poses for international law. Of course, as an international lawyer, it's an area of interest to me, but also as the moderator kindly indicated in the introduction, I am a member of the United Nations International Law Commission, and in that context, I've had the honor of co-chairing a state study group that just now in Geneva, a few days ago, finished its work on sea level rise in relation to international law. So I'm going to talk to you a little bit about that, and indeed it's fresh news, so you have the chance to hear it just as we have finished the work. I will also address briefly, because I think it comes under the questions that were asked to us in the panel, I will also talk to you briefly about how also international courts and tribunals are being asked to further clarify international law in what comes to dealing with the challenges posed by climate change. And indeed, this is an important moment in terms of climate change also being the subject of advisory proceedings, both before the International Tribunal on the Law of the Sea and now currently before the International Court of Justice. So I will try to touch on these two areas, which are also areas that I work on now in this turn as a legal advisor in the Ministry of Foreign Affairs, and having had also the privilege of representing Portugal in these two advisory proceedings. So I'll try to use what's left of my 15 minutes just to give you the highlights in this regard. And then, of course, I'll be very happy then to answer any questions you may have in the Q&A after also the other speakers. So, sea level rise. I'm sure that you all know that sea level rise is one of the adverse impacts of climate change. It's not the only one, but it's one of the adverse impacts of climate change. And it's one that has particular impacts because it may put in question in the most extreme scenarios. It's not the case for everywhere in the world, but in the most extreme scenarios, and this is something that has a clear scientific basis from the Intergovernmental Panel on Climate Change. In some cases, sea level rise related, climate change related sea level rise can lead to the submergence of land territories and even to what initially was called the disappearance of states, the sinking islands, disappearing states, especially in the Pacific Islands area and perhaps also in the Indian Ocean, the case of Maldives, and in the Caribbean. But the countries that are most at risk are some small islands in the Pacific, like Tuvalu or Kiribati. And that is unique if you think about all the different impacts of climate change. Desertification, drought, forest fires, they do not have the impact of a possible disappearance of a state. And then, of course, you link that with also a very unique impact that sea level rise may have, which is the impact on the maritime zones. Because if the land is shifting inwards, then either states will lose existing maritime zones because they will shrink, they will move inland, or they will have maritime zones that are not in conformity with the United Nations Convention on the Law of the Sea, which foresees that the territorial sea is 12 miles, the contiguous zone is 24 miles, and especially the economic exclusive zone is 200 miles. And of course, when the United Nations Convention on the Law of the Sea was negotiated and concluded, climate change was not specifically addressed. It was a concern that it was starting to appear in international discourse, and scientific data was starting to emerge. But really the assumption of climate change and sea level rise as a phenomena that could impact law of the sea only came later, late 90s, beginning of the 1990s. And of course, it's that date where we also have the first Framework Convention on Climate Change, the UN Framework Convention on Climate Change of 1992, that then was completed by a number of additional instruments, all the way up to the Paris Agreement that I'm sure everybody knows, the Paris Agreement of 2015. But these instruments, which are very important as international law instruments related to either law of the sea or related to climate change, they do not address the impacts of this phenomena of sea level rise. And there's an additional impact, which is, and that one may be common also to other adverse impacts of climate change, which is the forced movement of population. But that can also happen with desertification or forest fires, drought, but it's also very specific in the case of sea level rise, because if land is submerged, these phenomena are not temporary, in the sense that if people are displaced from their places of living, it will be impossible for them to come back. And in other adverse impacts of climate change, you could think that probably it would be possible. It would not be at least physically impossible for people to return. So it's because of this triple impact, an impact that is closely related to the elements of the state, to what the idea of a territory, the idea of a population, and the idea of a government, that the international community, and also because these were new issues, I mean, we never thought about a state disappearing due to physical consequences. You know, everybody knows that there's been many cases of state succession where states have been transformed. So, for example, when many of us in this room, virtually included, were born, we had a state called the Soviet Union, and now we don't have the Soviet Union anymore, and we have different states that were former Soviet republics, and now they're newly independent states. And so the phenomenon of state succession is not unknown to international law, but the physical disappearance of a state is new. This is not only if we come back to the myth of Atlantida, maybe we can think of an example where territory disappeared. So because also of the novelty of the questions, there was an interest of the international community, and that was clearly driven by the most affected states, to have some kind of legal responses to the issue of the impacts of sea level rise in relation to international law. And that's how the topic came to the International Law Commission, which is a body of the United Nations, expert body created by the General Assembly. So we report directly to the General Assembly, that has a mandate to codify and develop progressively international law. And the International Law Commission decided to do a study to address the legal consequences of sea level rise in these three different areas that I mentioned. So law of the sea, statehood, the possible disappearance of states, and also protection of persons affected by sea level rise. And we've just concluded, this is a process that started back in 2018, so some time ago, and we've now concluded with the final report of the study group that has some operational practical conclusions. That basically, after the study that we did in legal terms, looking at existing law and the possibility of interpretation of existing law, and also taking into account how state practice is developing, because we've also seen that in these last 5 years, as we were working, states were starting to take positions in these matters, and so what we call state practice could be taken into account. And we basically concluded that there have been, and this report will be public very soon, and I'm also very happy to share it once there's a clean version of the text, which should be out in a couple of weeks, to share it with the organizers so that it could be distributed. So we basically concluded that in all the three areas that we're working on, the idea of continuity, preservation, and protection of persons was possible, even though these issues are not specifically addressed in the Paris Agreement, or specifically addressed in the UNCLOS, or specifically addressed, for example, in human rights conventions. So states can, if they deposit their maritime zones in accordance with UNCLOS, there's no requirement to update those maritime zones in the face of climate change-induced sea level rise. There's no legal principle that would necessarily automatically lead to the disappearance, the legal disappearance of a state, even if its land is submerged. The state can continue to exist and can continue, for example, to be a member of the United Nations, because many of these small islands that are at risk, they are United Nations members. And also there's a principle of protection of persons affected by sea level rise. So it will be now very interesting to see what this study that we've concluded will have as an impact on the current situations, and also on some ongoing processes, political process and also legal processes at the international courts and tribunals. And so just a very, very brief remarks also on what's going on. So this is not, what I'm talking to you about is not traditional international lawmaking, in the sense that this is not being addressed by treaties, but there are other ways that international law can help dealing with the impacts of climate change, including this study to clarify the legal issues that we've just done at the International Law Commission, or the ongoing processes on before international courts and tribunals, such as ITLAWs, that was asked by a commission of small island states that was created to ask ITLAWs, the International Tribunal on the Law of the Sea, to give a legal opinion. So it's not a binding decision, but it's a legal opinion with a lot of authority about whether climate change, and in more specifically the greenhouse gas emissions, could be considered as a form of marine pollution. And if that was the case, if that would fall under Part 12 of the United Nations Convention on the Law of the Sea, which is the part about the preservation of the marine environment. And the International Tribunal on the Law of the Sea was very clear to consider that climate change and the greenhouse gas emissions was a form of marine pollution. So Part 12, that has a number of duties in terms of prevention, due diligence, cooperation, was applicable also in the context of climate change and of the impacts of greenhouse emissions in the oceans as a form of marine pollution. That's been, this advisory proceeding has been closed. There was big participation, many states were in agreement, and the opinion of the Court of May from last year is quite clear in the terms that I expressed. Now there's another ongoing process at the International Court of Justice that has a broader jurisdiction, so ITLAWs deals just with issues related to UNCLOS, but the ICJ has a much broader jurisdiction. And in a diplomatic initiative led by Vanuatu, also another very small state from the Pacific region, but in an effort that led to a unanimous resolution adopted by the General Assembly of the United Nations, there was a question put to the International Court of Justice about what are the obligations of states in respect to climate change, taking into account not just the Paris Agreement, which is of course a fundamental basis, the Paris Agreement and the UN Framework Convention from '92, but also taking into account all these other instruments and rules and principles of international law, including relating to the law of the sea, human rights, principles like polluter pays, the duty to prevent transboundary harm. What are, in this broader context, the obligations of states in relation to climate change? And then there's a second part of the question, which I think one of the speakers would also address. What are the legal consequences, so the responsibility, the consequences in terms of responsibility for states that have caused harm, to having into account these obligations that have caused harm to the climate systems in relation to other states, especially the most affected states, and also in relation to the communities and populations that live in those states. This advisory proceeding is, I'm just about to finish, this advisory proceeding is still going on, so states have made written submissions and oral submissions, about 100 states and international organizations, so really massive participation. And of course, we are now eagerly awaiting for the response of the ICJ, which should come sometime after the summer. And that will give more guidance as to international law and how to use international law to face the global challenges posed by climate change. And so I'll stop here. Thank you very much for your attention, and I'll happily participate in the Q&A session afterwards. Thank you very much.
Thank you so much, Dr. Patrícia. I'm sure we'll follow up, especially about the consequences to the countries. I'll pass to Professor Aldino Campos. Professor Aldino Campos is also a Navy officer. He holds a master's degree in geodesy and geomatics engineering, a PhD in territory engineering, and a PhD in international relations. He teaches at the Portuguese Naval Academy, And he's also a researcher at the research center of the Institute of Political Science of the Portuguese Catholic University. In 2017, he was elected as a member of the Continental Shelf Limits Commission at the UN. And in 2023, he was elected chair of this commission. Thank you so much for being here. The floor is yours, Professor.
Thank you.
Aldino.
And I'll start by greeting my fellow colleagues of the panel and also all the audience, and also Patrícia back home. It was great to see you. And I thank Patrícia for facilitating my job here, and I assembled some slides. And I'd like to share with you my perspective as a non-legal expert regarding a law issue, international law issue. Are we good?
I hope so.
Basically, I will start my presentation focused in one issue, one important issue, which is the time scales between the reality that we are facing today, that we have been facing for the last years, and the time scale for the response for those activities. Meaning, how fast can the international law respond to the events? And as we can see in the news, from day to day, we can see that the international order is changing, and that will be more and more difficult to implement. Basically, we have extreme events now that we are facing regarding to climate change, and we are drawing conventions, agreements, laws for 30 years now, and the impact is almost zero. We have some benefits, but it's not relevant for what we need. We have somehow, and we were discussing that yesterday, we have to suffer in our skin, in our body, the consequence to react. We are normally reactive bodies. So we, as you might remember during the pandemic of COVID-19, we react very fast because we were dying. So we can react actually very fast. But I can also give an example for the UNCLOS, for the United Nations Convention on the Law of the Sea. It was triggered in November 1967. I was not born in November 67, I was born 1 month later. And then the conference to discuss that issue raised by Abreu, which was the permanent representative of Malta to the UN, started 6 years later, in 1973, and the process ran to 1982, 9 years. So 6 years plus 9 years, and then we have to sign and ratify the process to the convention enter into force. And that took from 1982 to 1993, and 1 year later, the convention entered into force. By that time, I was already married. And we are not even engaging in the process. Now, when you look to the Continental Shelf process, under the convention, the application of Article 76 defined the extended continental shelf. It was a process that was expected to take no more than 10 years. And this process, the Commission was first established in 1997. We are now in 2025. We have more than 26 years now, and we are not even close to the half of the table. Okay, I'll keep going. So this time difference between the reality and the creation, the establishment of agreements, conventions to somehow control the damage, it's not aligned. The diplomatic and the political time scale, it's not the same as the climate change time scale. It's different. And we need to adjust this as soon as possible. And as you can see in that graphic, things are going to speed up now. And we have to be more efficient in creating these, establish these international law agreements to respond to the events. If not, we will fail. And then we will suffer in our skin, in our body, and then we'll react in the next day. And that will be tough, very tough. So we have to somehow, and I don't know why the slide is not all here, but it's okay. But the data, and as we have seen yesterday in the panels, the data is there. This is happening. This is the reality. So we have to align our timescales from the international law, the drafters of these conventions, these agreements, to the reality to help ourselves. Another issue, it's the responsibility, so the scale in terms of the geographic appliance of the international law. There are those that defend that should be at the molecular level, individuals. But then, if I'm going to my work in the morning and I take the bus and I see my neighbor taking the car, it's not fair. And that happens not at the molecular level, as individuals, but also at the state level. It's somehow complicated for a state to implement national law to prevent this type of actions, to reduce the consumption of fossil fuel, and you have your neighboring polluting. Since you are in the same, this is the global ocean. It's interconnected. We cannot just create little boxes and, well, he is polluting, he will pay for that. No, if he is polluting, everybody is paying for that. So global problems, global crisis requires global solutions. You cannot just stay at home and apply and draw solutions for your own. It should be at a larger scale, at a global scale. Okay, so we have this time frame, time scale problem, we have this geographic problem, and we'll go back to UNCLOS 101, the basics of UNCLOS. And this is how legal experts see the ocean. The scientists see a continuous body. You cannot issue a passport to a fish and tell the fish, well, you cannot go from Portugal to Spain, you have to stay here to be catch, to feed the Portuguese people. No, it doesn't work like that. That's the real world. It's the oceanography, hydrography, it's the chemistry of the water, it's the physical world. But then the legal experts create this, I would say, synthetic world when they divide it in several maritime spaces. And even to this, this was one of the topics, the transboundary resource management. We have mainly two types of overlapping. We have the Euclidean or horizontal overlapping, and you can see, for instance, in the Arctic, where all the states in the Arctic overlap their own continental shelves, and that will be a great problem in the future, how they will manage, how they split that area. If you go to South China Sea, it's the same. You have like 3 or 4 overlappings. Even in the Atlantic, in the Rockall area with Ireland, with Denmark, with UK, you have overlapping areas. Even Portugal and Spain in the extended continental shelf. So, and this is one problem that bilaterally countries have to solve. But you have also the vertical overlapping. For instance, the continental shelf, it's the extended of the seafloor. And on top of the extended continental shelf, you have the high sea. So how can you interact with your own extended continental shelf without affecting the high sea? Especially now that we have this BBNJ agreement, the High Sea Treaty, and nobody knows because it never happened. No one is actually exploring, drilling in the extended continental shelf. But in the future, we have to somehow, and we know that this will happen. And again, this is the time scale. We know that it's going to happen. We know that this is a problem, but the diplomatic and political timescale is different from the reality. It happened with UNCLOS, it happened with the agreements for climate change. We are always delayed. The reality, it's always ahead of the solution. And we cannot just continue thinking in trying to find solutions in the same way that we create those problems. We have to think differently. And I don't want to extend myself very much, but I would like to bring, and I'll thank Patrícia for her intervention, which is normally when we have an international problem, we try to find an international agreement, an international convention, an international arrangement to solve that problem. And that problem is somehow binded into specific limits. So we have ocean management problems regarding to the first convention on the continental shelf, which is one of the 4 conventions from the 1958 conference on the law of the sea. And we establish, as I said earlier, the United Nations Convention on the Law of the Sea, this unique package deal, okay? But then we have another conventions that deal with specific problems. And now we have climate change that is affected by a lot of conventions. And if you apply all of these conventions at the same time, you will be contradicting one to each other. So you cannot, if you agree with one or two, you are failing in another one. So that's why the merit of this work of that Patrícia is engaged, it's very important. Because we have to overcome, we have to have some ad hoc solution to the conventions that are already in place. I can give some examples, for instance, for UNCLOS, defining its Article 5, the baselines. And the baselines basically represents the low water line along the coast. And this is, as you saw as you have seen in the UNCLOS 101, that graphic, everything is measured from the baseline. So if sea level rises changes the baseline, and you have to update the baseline in your officially large-scale charts, it's mandatory according to IHO, which has specific standards, because it's an official document from the state, a nautical chart. So if you update those charts, you have to reflect your maritime space based on what you are publishing as in your nautical charts. 12 nautical miles for territorial sea, 24 miles for contiguous zone, 200 nautical miles for EZ, etc. Even for the extended continental shelf, for the constraint line of 350. Now, if you agree with that, then you have to retreat the 12 nautical miles. But then you have another convention, the Vienna Convention, the Law of the Treaties from 1969. And in this article reads, a fundamental change in circumstances may not be invoked as a ground for terminating or withdraw from a treaty if the treaty establishes a boundary. So imagine in 2 states, they have a boundary established, and that boundary established based on their own coastlines. And you have this Vienna Convention Law of the Treaties. You cannot change that line, and then you will violate because you are no longer respecting the baseline. Okay? So if you agree with one side, you will fail in the other side. The same with the islands. We have this definition in Article 121 that defines the concept of island and rock. And with sea level rise, if the sea level rise continues grow up as we listened to Mr. Ocean yesterday, can by somehow in any time, I hope not, to demote an island to a rock, because that had implication according to Anglos. If this work that Patrícia is working fails, the previous assumption is that it will lose Yesid, it will lose continental shelf, because then a rock can only generate territorial sea. So you lose rights over the resources that used to have before the sea level rise. And in the limit, and as Patrícia mentioned, it's the statehood of a state. Is it possible? Because I don't know if you were aware of the Montevideo, it's another convention, Montevideo Convention 1933, that defines the 4 requirements for a state to exist. In one of them, it's to have territory. So it's territorial, population, political system, and the ability to interact with other states. These are the 4 fundamental points according to Montevideo Convention of 1933. So if you lose territory, automatically you lose your statehood. So we have to have an ad hoc mechanism that overrides all these conventions, because all of them will fail. So if you retreat your baseline, you will have, and you keep your territorial sea, you will have territorial sea of 13 miles, which contradicts also the convention. So we have to have some loose system to overlap these previously established conventions that did not take into account the climate change. But now it's happening, and these are the effects. And the international community, no matter if we are going through a tough day regarding to multilateralism and changing the world order, we have to stand together and find solutions, because the sea level is rising now, but in the future it can go down again. So if the populations that Patrícia mentioned that should move from one side to the other, you can go to a surrogate state, but you can benefit from the resources that used to be yours. I will conclude my presentation here, and I will be happy to have a good discussion on this topic. Thank you very much.
Thank you so much, Professor Aldino. Admiral Omar Moreno Oliveros, bienvenido a las Azores. Admiral Omar Oliveros holds a master's degree in national security and defense and is pursuing a PhD in management sciences. He has held key leadership positions, including a naval attaché to Peru, submarine commander, and the director of the Directorate of Reserve Professionals. He is also a certified submarine commander from Germany, and he's currently serving as head of the Comprehensive Naval Education Office of the Colombian Navy. Thank you so much for coming. Please, the floor is yours.
Thank you very much. Initially, the intention is to share some experience from Latin America, and I will permit to read my presentation in order to give the correct message that we want to share to all people. Bom dia a todos. Gostaria de começar expressando meu profundo agradecimento ao almirante Bagrança, a sua equipe do Atlantic Center pela calorosa recepção e pela organização deste importante evento. Good morning, everyone. It is an honor to participate in the 5th Maritime Security Course. I bring warm greetings on behalf of the Colombian Law of the Sea Institute and the Colombian Navy. Today, I am pleased to share some reflection on the urgent and complex relationship between the climate change and international law, with a particular emphasis on maritime issues that affect our region and the global community. I hope this exchange of ideas contributes to strengthening our shared legal frameworks and collective maritime resilience. The Colombian Law of the Sea Institute is a young but ambitious initiative created to meet the growing need for maritime legal research and strategic analysis. Its establishment reflects national awareness of the sea's importance, not just for sovereignty and security, but also for their ecological, economic, and geopolitical value. The Institute promotes especially knowledge of the law of the sea with an international and forward-looking approach. You can see the symbol of our institute. Over the past 5 decades, Latin America has faced growing climate impacts for threatening its environmental, economic, and social stability. Key effects include rising temperatures, altered rainfalls, sea level rise, glacier retreat, stronger extreme weather events, biodiversity loss, risks to agriculture, health, and increased displacement. These escalating challenges require coordinated legal, political, and scientific responses across the region. Beyond environmental fragility, climate change poses direct threats on maritime security, making stronger legal frameworks and multilateral dialogue urgent. Key emerging legal and political challenges include ensuring legal stability on maritime zones as baselines amid shifting coastlines, addressing challenges to the immutability and intangibility of borders altered by physical change, the possible invocation in law of the doctrine of fundamental change of circumstances, in Latin, rebus sic stantibus. Managing discussions around the lands dominate the sea principle as territorio submerged. Responding to demands against history warriors, maritime claims, and the rights of a climate-affected coastal and island population. These are not theoretical. They are directly impact sovereignty, navigation, defense planning, and legal dispute resolution. Since the 1970s, global carbonic gas emissions have shifted, with East Asia in blue color, South Asia in brown color, and the Middle East in red color, now playing a larger role, while high-income countries have reduced their share. This significant highlights the importance of the common but differentiated responsibilities. Historical emitters must honor their legacy, and the emerging ones must act according to their capacity to meet climate goals. In this context, call for a stronger climate governance and multilateral cooperation. The Atlantic Ocean is not just a space for navigation. It is a corridor of climate interaction. The Caribbean Sea is connected to a vast ocean currents and is regularly affected by tropical storms that originate across the Atlantic. This interconnectedness demands that we develop coordinated and global legal responses, especially for small vulnerable states. Latin America and the Caribbean are especially vulnerable to climate change, with rising sea levels, extreme weather events, and biodiversity loss, generating serious economic, social, and legal impacts, particularly for coastal and island nations. In Colombia, the challenge is also geopolitical, as climate-related risks intersect with the maritime disputes, such as the ongoing case with Nicaragua over the Colombian archipelago of San Andrés, Providencia, and Santa Catalina, adding layers of legal and territorial complexity. The Colombian Navy, in coordination with the scientific and legal experts, supports the state through research and strategic analysis, demonstrating that in times of environmental transformation, defending sovereignty requires both legal insights and scientific understanding. In Panama, over 300 families from the Gunayala archipelago have been displaced by chronic flooding and sea encroachment. This situation raises urgent legal questions. What happened with the sovereignty of submerged lands? How are population rights and property titles guaranteed when the physical territory disappears? How should the international community respond to climate-induced displacement? These answers will shape the future of coastal population, the evolution of maritime law, state responsibility, and human dignity in the face of climate change. Colombia's maritime geography, bordering both the Caribbean and the Pacific, gives a distinct bioceanic identity, amplifying its environmental, geopolitical, and legal responsibilities. Our maritime territory is nearly as extensive as our land territory and supports over 6 million Colombians who rely on the sea for fishing, tourism, trade, and cultural life. These zones are also defined by complex maritime boundaries with neighboring states, requiring constant legal negotiation. Now further complicated by emerging risks to climate change. Colombia is already facing severe effects of climate change, especially in its insular Caribbean region. A key example is Hurricane Iota, which hit the archipelago of San Andrés, Providencia, and Santa Catalina in November 2020. These Category 5 storms caused massive damage, destroying infrastructure, displacing communities, and devastating ecosystems. In Providencia, over the 98% of structures were affected, turning the storm into a national emergency. Iota showed how climate change is intensifying tropical storms with a disproportionate impact on a small island. It raises urgent challenges for defense, disaster response, legal protection, and long-term recovery. This slide highlights a key example of Colombia's legal and territorial vulnerability to climate change. Quitasueño, a remote coral formation in the southwestern Caribbean. A structure like QS-32, a small rocky elevation, are legally significant, and the enclosed features above water at high tide can generate territorial sea and contiguous zones. Colombia has used such features to support its maritime claims. But if sea level rise or a storm erode or submerge them, could Colombia lose maritime space or have its baseline altered? These are the risks of sovereignty, boundaries delimitation, and regional stability. The Caribbean and Pacific coasts are more to coral reef, mangroves, seagrass beds, and wetlands essential for biodiversity, food security, and climate balance. These ecosystems face growing threats from climate change, coral bleaching due to the warming seas, ocean acidification, stronger storms damaging habitats, and sea level rise disrupting coastal areas. The loss of the marine biodiversity undermines not only the environmental, but also the livelihoods and cultural identity of coastal communities. Protecting it is both a scientific and legal duty, and Colombia is committed to strengthening its laws and institutions to ensure long-term ecosystem resilience. Now, we enter more strategic section of the presentation. The Colombian Navy and the Law of the Sea Institute, ICDEMAR, works together on the key issues that merge legal, environmental, and defense concerns. In the following slides, I will present some of the topics we address and Colombia's legal responses to emerging maritime threats. Colombia actively engages with international legal developments on marine protection, close following the work of the International Tribunal of the Law of the Sea and the interpretation of the United Nations Convention on the Law of the Sea in response to environmental challenges. Through ICDEMAR and other institutions, we seek to strengthen legal capacity, engage with the global legal community, and promote interpretation that reflects the evolving realities of today's oceans. In Colombia, applying international legal standards is not symbolic, it's operational. Institutions like Colombian Navy and DIMAR play a key role in incorporating decisions from bodies of ITLOS into national legal and administrative systems. This alignment is vital for marine protection, as climate change has made ocean governance a strategic priority. This slide calls for global dialogue and cooperation, as protecting the ocean from climate change requires both national and collective action. The oceans unite us. Making forums like this, organized by Atlantic Center, key to promote shared legal strategies and resilience. Colombia values these spaces, understanding that the future of the maritime law relies on common principles, flexible frameworks, and global engagement. Colombia is fully committed to the Paris Agreement and has adopted concrete tools to turn these global goals into long-term national policy. Most notably, the E2050 climate strategy. This roadmap guides emission reduction, climate adaptation, and ecosystem protection across sectors such as energy, transport, agriculture, and the blue economy, with an emphasis on resilience, climate justice, and the protection of coastal and maritime ecosystems through institutional strengthening and legal alignment with the international goals. The COP16 Biodiversity Summit, held in Cali in 2024, brought together over 12,000 participants, 1,000 events, and 900,000 visitors, mobilizing more than $75 million United States dollars and positioning biodiversity as a global priority. As a key outcome, Colombia launched the 2030 Biodiversity Action Plan, outlining 6 goals and 191 actions to guide national conservation over the next decades. The summit reaffirmed Colombia's environmental commitment and called on all nations to share responsibility in addressing the global impacts of climate change. Colombia also has a dream in which nations can build together a path to their own development, protecting natural resources and preventing biodiversity, so that our children not only receive a world, but they are able to receive a better world. Thank you very much.
Thank you very much, Admiral Moreno. So I think we have about 12 minutes until the end of the panel. I do have some questions, but I think maybe we should give a chance for the audience to start a Q&A. I don't know if there is a microphone available. Thank you.
Thank you so much. This is for the first presenter. I just have a very quick question about whenever we get the output of the ICJ, will this actually influence in any ways the negotiations or anything else? Or I mean, it's an opinion, but yeah, just want to know what will be the consequences.
Good morning. The question is also to Professor Patrícia and also to Commander Aldino, because I do understand the appeal of the interpretation that is being made in the study, which is to give primacy to the protection of the people and the rights acquired by the people. But I do, as a legal person, feel conflicted because it seems like we are providing a higher level of importance to the element of people in the state regardless of the land. And my question then would be, what would be the interpretation of the International Law Commission in case the population of a state disappears? Does the state continue to be a state if it has no population? This is the conflict that an opinion such as this may create, because for me, if the population ceases to exist, it makes no sense to maintain the rights and the land of a state that has no population. And the question is how do we interpret and how do we value each of the four integral parts of a state? Because with this opinion, it seems like, okay, then land doesn't matter. You maintain all your rights because what's important, it's the people. But then I guess, because then we have the case of Tuvalu, which is now a digital state, so it has no land, or this was what they were trying to do. And I, as a legal person, I mean, it's very conflicting. It's very interesting, but I just want to hear your thoughts on that. And to Commander Aldino, since you are in the Commission on the Limits of the Continental Shelf, and I know how long the negotiations take to establish an extended continental shelf finally legal and binding, but also, like you said, you also have the obligation to update your baselines, and ultimately everything is going to be dragged down, which I'm not completely against, because the UNCLOS also has the principle of land dominates the sea. If there's no land, you are not guaranteed maritime rights, even though you had them in the past. So it's very confusing. Of course, the work is very important, and I'm sure that you had people very smart and thinking about this. But like I said, it seems like you are picking which of the four you consider to be the most important, and in that case, I just think maybe you should revise the Montevideo Convention and then take the land out of it. Thank you.
Should we start answering the... So maybe, Dr. Patrícia, did you get both questions?
Yes.
Thank you.
So, no, thank you so much for the question. So on the first one, what impact could the advisory opinion of the International Court of Justice have on negotiations? I'm assuming you're speaking about climate change negotiations. In fact, I think the request of the advisory opinion of the court came out of a sense of frustration from some countries, especially the most affected that have least contributed to climate change, a sense of frustration from the climate change negotiations. And so I think whatever comes out of these proceedings, well, depending on the content, it will certainly be used in negotiations. How far that will go, that I think it's the big question that we have to wait a little bit more to understand how far the court will go and how far that can be used in climate change litigation. Also, because I think this is an important dimension. If the court is very forthcoming in terms of making a link between the impacts of climate change and the duty to compensate in terms of the law of state responsibility, then I think that's going to open the door for climate litigation, and also that's going to strengthen the request of the most affected states for more money for measures of adaptation, and so I think that will be certainly used. How much and with how much success, it depends on what the court will say. Of course, one has to bear in mind that the request to the court was for an advisory opinion, and so it's not binding. It's not binding, it's an opinion of the court, but it has a lot of authority. So certainly it will be used. Then on the second question, I think I recognize the voice of Inés Aguiar Barranco, and so thank you very much for the question. So I understand. I mean, the issues that are being discussed here, they are difficult. I hope I didn't try to oversimplify in terms of saying that the solutions are easy. But I think what we really tried in our work in the ILC, and I'm also very grateful for some of the comments that Aldino made in his presentation, because what we were trying to do, and of course in a different way than doing a convention, negotiating a convention, which takes time, and it takes time for its entry into force, and it's not guaranteed. And so with this criticism that international law is always late, is always reactive, is always in international humanitarian law, sometimes people say that international law is always one war late. And here I think we know, he also spoke about the pandemic, and we could also say that international law was one pandemic late, because only now we've negotiated a treaty, a pandemic treaty. And for climate change, we do have some instruments, but we also need to be more proactive and give solutions. And I think this alternative ways of working, either through studies of the International Law Commission or through resort to courts and tribunals, may be more expeditious and more focused. And so, but the issue that we really try to do, and that's also a point that I think Inés raised in the question, and that Aldino also mentioned, is to reconcile the possible interpretations of international law, to make them make sense and not contradictory, Of course, as one of the conclusions, I think that's an important conclusion that we arrived at, is that the Montevideo Convention is an old convention. It's almost 100 years old. It's from 1933, and it was done for very specific purposes, and much more for the creation of the states, and not so much for the continuity of the state or the possible disappearance of the state. And when we look at the elements, there is a certain flexibility. So when there's this idea that once a state exists, a state can do anything to continue its existence. It can take lawful measures to continue its existence. And then the other thing is that the element of population has always been seen with a certain degree of flexibility. If one thinks of Palestine, for example, where either the territory and the population, it's not a single unit, or Western Sahara, that could be a state with nomadic population. So the population element has been seen as a flexible element, and also the territory could be discontiguous. And here, I think the approach that we took, and that was also because we had, and I think maybe that's more connected to the question you asked to Aldino, and I will not enter too much into that, but we had some discussions about whether the land dominates the sea principle had an impact here. But the idea is that the land territory, in a way, does not disappear. It becomes submerged, but it was there, and it's still there in a way. And the population does not disappear either, because they may go to other places, including to foreign states. But it's possible for the state to continue having a human substract in a diaspora, and for it to continue to make sense to have financial resources that come out, for example, of the exploration of maritime zones. I think we have to really think about this as a whole, and trying to have an interpretation of international law that is coherent and not contradictory. But then, of course, it's one thing to discuss what's happening now in the near midterm, and then what may happen in 100 or 200 years. And then, I don't know, we will not be here to discuss that, but I think that discussion is going to come up again. So I'll stop here, not to take too long. Thank you.
Thank you. First of all, Aldino.
Thank you, Inês, for the question. Well, thank God for the Commission, we do not consider the baselines. So the Commission just receives the baselines from the coastal states, and that's one of the critical issues that I don't want to know. I don't want to check if the points are in the water or are inland. We have to believe the state, because it's a national, it's a domestic law. As Portugal has our own baselines, normally, mainly the straight baselines together with the nautical charts that represents the normal coastline. So we have to rely on those elements that coastal states submit to the Commission, and we don't raise any issues at all. I'd like to go back to the question of population and the issue of territory and population. So if a population is totally evacuated from one state to a surrogate state or a twin state, by agreement by those states, if the population continues to have a national passport, you still have a population. It's living elsewhere. It's not living in the original territory, but you have the population. Oh, but that's not our problem. It's no longer our problem. But in this case, in diaspora, you have citizens from Portugal all over the place. It's population, Portuguese population. And nothing prevents that the sea level goes lower again in the future, and then they can go back. The question is whether or not you lose the acquired rights from the past. You can benefit from the right. Can you continue fishing in your own EEZ, or used to be your own EEZ, generated by land? So under the principle that land dominates the sea, you need actually, for instance, for continental shelf, you have to demonstrate the natural prolongation of the land territory up to the edge of the continental margin. So you have to demonstrate that, and that's an exercise that needs to be demonstrated for us to engage in the process. What do you call a pertinency test? So you need to demonstrate that. Otherwise, it will fail in the beginning of the process. So again, baselines, it's an issue, but not for the Commission.
My battery is changing, but I think we are. Time is up. Maybe if there is one last question.
Thank you very much. I'd like to pick up on the discussion, on the legal discussion, and I'd like your comments from the panel on the agreement between Tuvalu and Australia. As far as I know, is the first and so far only international agreement between two sovereign states, where one sovereign state opens the door to the population of another sovereign state in case of environmental catastrophe. Is there follow-ups on the legal structure of this arrangement? Because the treaty itself is very simple. The Australians will give visas to the Tuvalus, the 12,000 Tuvalus, in case of Australia is like a small city, to move to Australia if Tuvalu becomes inviable. But is there the follow-up of this simple treaty? Issues that you've been touching upon but not dealing with, like the sovereignty of the water column, or the capacity to make decisions as a Tuvalu, if they all move to Australia under this treaty. Thank you.
Responde a Patrícia?
Se a doutora Patrícia gostaria de responder?
Posso. It's a pleasure also to see Bernardo Yves Cruz in the audience. I'm really sorry, even getting more and more sorry that I wasn't able to make it to the beautiful island of São Miguel. So the Australia Tuvalu Gallipoli Union Treaty, it's a very interesting example, and it was not done without a certain criticism. There was some initial criticism because it's as it was said, the first treaty of its kind, in the sense that a larger country accepts to receive not all citizens at the same time, but with a certain quota, yearly quota, citizens from Tuvalu that are specifically affected by climate change induced sea level rise, as a form of mobility pathway and possible legal residence in the country. And so it's quite interesting from that point of view, because it's the first treaty of its kind. But there was some controversy, of course, because this comes in a package that has to do also with Tuvalu aligning with Australia in terms of the geopolitical and geostrategic issues in the Pacific, where certainly nowadays between the US and China, it's an important area. So it's a quid pro quo type of agreement. And so there was some discussions, there was a change of government, it took some time to be ratified. But in fact, now it's being seen, and that's what we've also documented in our work in the ILC. States have been considering this, I mean, regardless of the concrete circumstances. I don't think states are taking a position on that, but they are seeing this as possibility, as a good practice, as a good example, that certain states can do bilateral agreements whereby they accept, not as climate refugees, because that's something that doesn't exist, but as legal residents, even with certain quotas, inhabitants from most affected countries. And so I think that we're going to see, as a follow-up, and especially in the Pacific Islands, we're going to see more of this type of arrangements. I'll stop there, but I mean, I could continue, but I'll stop.
Salina, I don't know if you want to add.
I heard that maybe Maldives and India, they are engaging dialogue for similar process. So again, when we start suffering in our bodies, we have to find solutions. And I believe if this event will take place in a stronger way, we'll have more examples. And this one will be a trigger one. It will be an example one. regarding to the issue of losing sovereignty over the water column, and so if we apply the convention UNCLOS purely, it's the principle that lands dominates the sea, and you need to have, for instance, for the islands in Article 121. You need to be an island with a sustainable economy and population to generate all this maritime space. Territorial sea is the continental shelf, even extended continental shelf, if applies geologically. But if you are demoted for, or if you are not even an island, you are a rock, then you can only apply territorial sea. And if you're not even a rock, then you lose everything. But the idea is to preserve what you have so far, and if you deposit, and those maritime space will be guaranteed in the future in this transitional or ecological era. Because you don't know what will happen in the future. We can go up, like in the Kevin Costner movie, like Waterworld, and just looking for some land, or you can having like extreme events like a super volcano when you enter in new ice age and the sea level goes down again. So it's unpredictable. So. But the law is there, and I would see this approach from ILC as an exception under very special circumstances, and climate change is the special circumstance in this case.
Thank you so much. I think our time is up. Well, I'd like to thank so much the speakers for sharing your expertise and for being here. Thank you so much.
So we will now pause for a short coffee break, 15 minutes. Okay, thank you very much. Francisco, pen. Ela sabe qual é que...
Recording stopped.